Friends, welcome back. We'll continue with the balance sections of this companies incorporated outside India from our law. Let's go to section number 388. Provisions as to experts consent and allotment. So whenever you are giving any prospectus, there will be some statements made by an expert stating that this particular company is true, the net worth of this company is so and so, it has a future prospects as this. So some expert opinions will be taken so as to attract the investors. So whenever any expert statement or expert's consent and allotment has been, any prospectus has been issued, and where such expert has withdrawn his consent before the issue of the prospectus or before giving such a prospectus for registration, these things has to be taken care of, because the expert has already withdrawn his consent, and now while issuing your prospectus to the public and you are saying that the particular expert is giving his consent, it may mislead the investors. So this particular point has to be taken into consideration. Let's go through the provisions. According to this section, no person shall issue, circulate or distribute in India any prospectus offering for subscription in securities of a company incorporated or to be incorporated outside India, whether the company has or has not been established or will not establish a place of business in India, if where the prospectus includes a statement purporting to be made by an expert, he has not given or has before delivery of prospectus for registration withdrawn his consent to the issue of prospectus with the statements included in the form and context in which it is included, or there doesn't appear in the prospectus a statement that he has given and he has withdrawn his consent as aforesaid, or if the prospectus does not have the effect where an application is made in pursuance thereof for rendering all persons concerned bound by the provisions of section 33 and 40 so far as applicable. For the purpose of this section, a statement shall be deemed to be included in the prospectus if it is contained in any report or memorandum appearing on the face thereof, or by reference incorporated therein or issued therewith. So if any expert has given his consent, but after looking at the prospectus, he is of the opinion that his consent has been incorporated in the prospectus in a wrong way, and such incorporation will mislead the investors, then he may withdraw his consent in writing. So his consent has to be withdrawn in writing, and such withdrawal of consent has to be clearly taken care of while issuing your prospectus. And in case if the prospectus has not removed his particular expert's opinion, then this expert may on an application bound all the persons concerned with the provisions of section 33 and 40. And even if any particular statement has been included in memorandum or articles or any other official documents of a company, such particular notes or particular wordings will be deemed to be as included in the prospectus. That is section 388. And then comes registration of prospectus, section 389. So whenever you are issuing any prospectus, that is whenever a foreign company is issuing prospectus, it has to register a copy register the prospectus with the registrar of companies. Only after registering it should issue these prospectus to the public. So while issuing to the public also, it should clearly specify that this particular prospectus has already been registered with the registrar of companies. Okay, let's go through the provision. No person shall issue, circulate or distribute in India any prospectus offering for subscription of shares of a company incorporated or to be incorporated outside India, whether the company has or had not established or will not, when formed, will or will not establish a place of business in India, unless before the issue, circulation or distribution of prospectus in India, a copy thereof certified by the chairman of a company and two other directors of a company as having been approved by a resolution of the managing body has been delivered for registration to the registrar, and the prospectus states on the face of it that a copy has been delivered, and there is endorsed on or attached to a copy any consent to the issue of prospectus required under section 388 and such documents as may be prescribed. It is saying before issuing to public, this prospectus has to be approved by the chairman of a company and two other directors, and this prospectus has to be approved by a resolution, and a copy of which has to be sent to the registrar. And after this, you are issuing this prospectus to public, so you should clearly state that a copy of this prospectus has already been delivered to the registrar of companies on the face of it, and if any acknowledgements that you have registered with the ROC has to be attached with your prospectus. According to Companies Registration of Foreign Company Rules 2014, the following document shall be annexed to the prospectus. What are the things that is to be annexed? Consent to the issue of prospectus by any person as an expert. So if there is any expert statement included in your prospectus, the consent from the expert has to be included. Copy of contract for appointment of managing director or manager. If you have already entered any contract between between other persons to be appointed as a managing director or manager, then such copy has to be attached. If there is no such written agreement between you and you have decided orally, then the particulars of all these things, a memorandum containing full details has to be disclosed. A copy of any other contracts entered, material contracts entered, not during the course of business, but entered within preceding 2 years. So if there is any material contract preceding 2 years, then such contract has to be disclosed of. A copy of underwriting agreement if you have entered any, and a copy of power of attorney if the prospectus is a duly authorized agent. So if a prospectus is not signed by the directors but by their agents, then a copy of power of attorney to such effect has to be attached with your prospectus. Then comes offer of Indian Depository Receipts, that is IDR, which is discussed under section 390. So for the purpose of this section and according to the Company's Registration of Foreign Company Rules, IDR means any instrument in the form of depository receipt created by a domestic depository in India and authorized by a company incorporated outside India making an issue of such depository receipts. According to section 390, notwithstanding anything contained in any law for the time being in force, the central government may make the following rules as applicable. The offer of IDR, the requirement of disclosures in the prospectus or letter of offer issued in connection with IDR, the manner in which IDR shall be dealt within the depository mode and by custody and underwriters, and the manner of sale, transfer or transmission of IDR. So in particular to offer, issue, transfer, sale, and the manner in which these has to be addressed, all these things the central government may make special rules and regulations that are applicable. And according to the Company's Registration of Foreign Company Rules, no company incorporated or to be incorporated outside India, whether the company has or has not established or may not establish any place of business in India, shall make an issue of Indian depository receipts unless it complies with the conditions mentioned under this rule and in accordance with the SEBI regulations 2009, and SEBI regulations means ICDR regulations, issue of capital and disclosure requirements, and any directions issued by the RBI. So before issuing IDRs, the company has to comply with the SEBI rules and the RBI rules along with the conditions that are prescribed under these rules, that is Registration of Foreign Company Rules. The rules relating to the offer, disclosure requirements and manner of transfer or sale, etc. relating to the IDR are contained in Companies Rules 2014, that is for registration of foreign companies. Let's move on to the section 391, that is application of sections 34 to 36 and chapter 20. According to the provisions of section 34 to 36, both inclusive, that is 34, 35, 36, all there is 3, shall apply to the issue of prospectus by a company incorporated outside India under 389 as they apply to the prospectus issued by an Indian company. So even if such prospectus is issued by a foreign company, all the provisions that are applicable to issue of prospectus by an Indian company has to be complied with. Whether it is foreign company or Indian company, if you are issuing prospectus in India, then all the rules of Companies Act has to be complied with. All the provisions of Companies Act has to be complied. The issue of IDR by a foreign company. So while issuing, you need to undertake some liabilities also. That is section 34, criminal liability for misstatements in prospectus. 35, civil liability for misstatement in prospectus. 36, punishment for fraudulently inducing persons to invest money. So if you are issuing IDRs, these are the three liabilities that you need to undertake, and you are subject to these three sections, 34 and 35, 36. Subsection 2 provides that subject to the provisions of section 376, the provisions of chapter 20 shall apply mutatis mutandis for the closure of business of a foreign company in India as if it is a company incorporated in India in case such foreign company has raised monies through offer or issue of securities under this chapter which have not been repaid or redeemed. Suppose if a foreign company has taken monies in the form of issue of shares or deposits, and if such company has failed to repay or redeem them, then all the provisions of section 20 to close the company will apply mutatis mutandis as if it is a company incorporated in India. And what are the punishment for contravention? Before going through this section, I will just brief you about this section. In case of a company, it is penalty. Penalty minimum 1 lakh, maximum it extend up to 3 lakhs. And if the contravention continues, it is 50,000 per day for every day of default after the first during which the contravention continues. And in case of every officer in default, it is imprisonment which may extend up to 6 months and fine 25,000 which may extend up to 5 lakhs or both. Hope you are clear with this question. I am repeating it with this section. I am repeating it again. Section 392 says, in case of any default by a foreign company, company shall be punishable with a fine of 1 lakh which may extend up to 3 lakhs. And in case of continuing offense, it is 50,000 for every day after the first during which the contravention continues. And in case of every officer in default, the imprisonment which may extend up to 6 months or fine minimum 25,000, maximum 5 lakhs or both. Hope you are clear. That is what has been written in this question. Sorry, in this section. Hope you are clear with this. I am skipping this off because you may confuse. And then comes section 393. Company's failure to comply with provisions of this chapter not to affect the validity of any contract. Suppose if a company has failed to comply with any of the provisions, that doesn't mean that the agreements, contracts entered by the company with other persons is void. So the validity continues to exist, but the company and every officer in default will be punishable under section 392. That's all with this chapter. We'll go through these questions that are given in our test your knowledge. Videshi Limited, a foreign company established with a principal place of business at Kolkata, West Bengal. The company delivered various documents to the Register of Companies. State the number of days and place where the said company shall deliver such documents. Where, within how many days? 30 days from the date of setting up a place of business in India. To whom? Registrar of Companies having jurisdiction over New Delhi. So the correct option is within 30 days to the registrar having jurisdiction over New Delhi. Let's move on. Ester Limited, a foreign company with a place of business in India, was established to conduct a business online as to data interchange and other digital supply transactions. The said company failed to deliver within the prescribed time period some desired documents to the Register of Companies in compliance with Companies Act 2013. State the penalty cast on Ester Limited for the cause of its failure. Here the question has clearly given state the penalty for Ester Limited, that is the company. So don't be confused and write all these penalties, both the company and the officer in default. So the question is clear about the company. We will answer from the company's point of view only. It is fine of minimum 1 lakh which may extend up to 3 lakhs, and if in case of a continuing offense, it is 50,000 for every day. Hope you are clear. So the answer will be Ester Limited punishable with a fine levied 1 lakh to 3 lakhs plus additional fine up to 50,000 in case of any continuing offense. Then let's move on to the next question. Radix Limited is a company registered in Thailand. Although it has no place of business established in India, it is doing online business through remote delivery of healthcare services in India. State the incorrect statement. State the incorrect statement as the nature of Radix Limited in the light of Companies Act 2013. The question is asking incorrect statement. So please read MCQs twice so that you will understand what the question is asking. So here the question is asking what is the incorrect statement from the options given below. So this company is registered in Thailand and it is delivering healthcare services remotely, that is through online business. So this is a foreign company as per Companies Act. So you are clear till here. Let's go through the options first. It is not a foreign company as it has no place of business established in India. But as per the definition of foreign company, if you are doing online business also, you will be treated as foreign company, whether your server is in India or outside India. So the first option itself is an incorrect statement. Let's go through the other options also so that we'll have some clarity. It is a foreign company being involved in business activity through telemedicine. Yes, it is correct. It is a foreign company as it is doing business through electronic mode. Even this statement is correct. It is a foreign company as it conducts business activity in India. So the balance 3, B, C, D and options are correct. Option A is incorrect statement. The question is asking incorrect. So answer is A. Let's move on. There are some descriptive questions as well. As per the provisions of Companies Act 2013, what is the status of XYZ Limited, a company incorporated in London, UK, which has a share transfer office at Mumbai? Merely because a company is having share transfer office in India doesn't mean that it is a foreign company. It will be treated as a foreign company only if it conducts any business activity in India. This similar question has already been given in example to this to section 393, if I am not wrong. Sorry, 386. So merely because a company is having share transfer office in India doesn't mean that the company is a foreign company. If the company has any business activity in India, then it shall be treated as a foreign company. And same section applies to the next question also. ABC Limited, a foreign company having its Indian principal place of business at Kolkata, West Bengal, is required to deliver various reports to the Register of Companies under the provisions. Sorry, this is a different question. You are required to state where the said company should deliver such documents. You already know that it is ROC having jurisdiction over New Delhi. And in case a foreign company doesn't deliver its documents to the ROC required under section 380 of Companies Act, state the penalty prescribed under the said act. Here the question is asking state the penalty. It is not clearly specifying whether it is a company or officer in default. So you should write both. For company it is 1 lakh minimum and maximum 3 lakhs. For continuing offence it is 50,000 per day after the first during which the offence continues. And for every officer in default it is imprisonment which may extend up to 6 months, fine of minimum 25,000 which may extend up to 5 lakhs or both. Hope you are clear with this. These are simple straightforward questions which are being given based on the sections. And let's move on to the second question. DEJY, a company limited incorporated in Singapore, desires to establish a place of business at Mumbai. You, being a practicing chartered accountant, has been appointed by the company as a license officer for compliance of legal formalities on behalf of the company. Examine the provisions of Companies Act 2013. State the document you are required to furnish on behalf of the company on the establishment of place of business at Mumbai. It is like section 380, where you need to give all these documents like charter, statutes, memorandum of association, details regarding the directors and secretaries, place of business incorporated in India, person, full address of the agent or the office on whom at which the any notice or documents has to be served upon the company. So all these details has to be given. This is under section 380. Let's go through this question answer also. See, Section 380. Every company shall, within 30 days from the date of establishment of a place of business in India, has to deliver to the register for registration the following documents: the charter, statutes, memorandum or articles, full address of registered office of principal, registered or principal office of a company, list of directors and secretaries, directors and secretary details like personal name, surname, former names if any, father name or mother name and spouse name, date of birth, residential address, nationality, income tax, PAN, and if the person is a director in any other company, then his din and sin of the company in which he is a director. In case of a secretary, his membership number, email ID, all these things has to be given. Name and address, and the name and address of persons resident in India for service of process or any notices and other documents required to be served on the company. Full address of office of a company in India deemed to be the principal place of business. Particulars of opening and closing of place of business on earlier occasions, if any. Declaration that none of the directors has been convicted or debarred from formation of companies and management in India. Any other information as may be prescribed shall be given to the ROC having jurisdiction over New Delhi. Hope you are clear. This is a simple, straightforward question which has been based on section 380. Then let's move on to the next question. ABC Limited, a foreign company, failed to deliver some desired documents to the Register of Companies as required under section 380 of Companies Act. State the provisions of penalty prescribed under this act which can be levied on ABC Limited for its failure. It is asking on the penalty for company ABC Limited. It is minimum 1 lakh, maximum 3 lakhs. For continuing offence, it is 50,000 for every day after the first during which the offence continues. Let's move on to the next question. Question number 4. Robertson Limited is a company registered in Thailand. Although it has no place of business established in India, yet it is doing online business through telemarketing in India. Whether it will be treated as a foreign company as per Companies Act? Yes, it has to be treated as a foreign company because foreign company definition itself says whether you are doing business through a place of business in India or through agent or through electronic mode, either directly or indirectly, or any other mode like emails, social media, all these things has to be treated as, such company has to be treated as a foreign company. So it is merely like write the definition of foreign company under section 2 and then state that this company, this Robertson Limited is doing online business through telemarketing and hence it has to be treated as a foreign company. Then the last question, Galileo Limited is a foreign company in Germany and it established a place of business in Mumbai. Explain the relevant provisions of Companies Act 2013 and rules made thereunder relating to the preparation and filing of financial statements and also the documents to be attached along with the financial statements by the foreign company. Hope you remember that form FC3 for filing of financial statements to the Register of Companies within 6 months from the end of the relevant financial year. Let's move on to this answer also. But before going through the answer, let's try to recall these points. What all you need to submit along for filing your financial statements? First thing, you need to file form FC3 along with prescribed fees within 6 months from the end of the financial year. And to form FC3, you need to annex your standalone financial statements, consolidated financial statements of the parent company, which the parent company has submitted to the relevant authorities in the home country, a list of all places of businesses, statement of related party transactions, and a statement of repatriation of profits. All these things has to be annexed. Hope you recall few points. Let's move on to the answer. Preparation and filing of financial statements by a foreign company. According to section 381 of a Companies Act, every foreign company shall in every calendar year make out the balance sheet, profit and loss account in such form containing such particulars and including or having attached or annexed thereto a copy of those documents to be delivered to the registrar. And documents required to be annexed under chapter 9 accounts of company. and copies of latest consolidated financial statements of parent company as submitted by it to the prescribed authority in the country of its incorporation. So the central government may provide some relaxations also. If any of the specified documents are not in English, then a certified translation thereof in English shall be annexed. Every foreign company shall send to the register along with the documents a list in the prescribed form of all places of business established by a company in India as on the date of balance sheet. Also, it should submit register of companies along with the financial statements in form FC3 with such fees as provided, and a list of all places of businesses established by a foreign company in India. According to the company's registration of foreign company rules 2014, if any company ceases to have place of business, then it should give a it should give an intimation to the register, and from that date the company ceases to have an obligation to deliver any document to the register, provided if it has no any other place of business in India. And according to company's rules 2014, further, it has to annex statement of related party transaction, repatriation of profits, statement of transfer of funds, that is including dividends if any. So the above statement shall include such other particulars as prescribed in Companies Rules 2014 relating to registration of foreign companies. All these documents shall be delivered to the register within a period of 6 months from the closure of financial year of the foreign company to which the documents relates. Hope you have revised along with me this chapter. This is such a simple chapter, only few sections has been given to us, and this chapter is too small to go through, and few important points has to be remembered, like the penalties, the documents that are required for registration, and what are the conditions for IDR, all filing of returns, filing of your financial statements, that is form FC1, FC2, FC3, FC4, all these few things to be remembered. That's it. This is such a simple and easy chapter. Hope you have revised with me, and we'll continue with the compiler on this chapter in our next video. By this, we have completed our study material from ICAI. Hope this video is helpful to you to revise this chapter as quickly as possible. Okay friends, we'll sign off here. Please do like, share, subscribe and comment so that it will be a boosting for me. If you like the video and comment the video, it is like a boosting for me to continue and to upload more videos of CA final revision. And I'm planning to upload audit also, but it is not like a full length video. It is like a short videos on the complete audit, but it goes on till the exams, that is till March 31st. What is my opinion is, audit is such a subject that you need to revise on daily basis. So till March 31st, you will be having a continuous videos on audit, so that you will revise slowly part by part, and you will complete audit and you will remember also. Hope this video is helpful. Okay then, bye bye. Thank you.